Um, as Ajay pointed out, it's a very hot topic and everyone's a little bit nervous about the subject matter right at this moment in time, but it's completely not linked to the acquisition or any other timing, absolutely no link. This in fact came about really out of a real life case that we had where we were dealing with a specific individual in the company where we had some sticky issues with respect to departure from the company, and actually that was a learning lesson for everyone. I think it was a learning lesson for the managers, it was a learning lesson for HR, it was a learning lesson for the regional team in terms of how we coordinate these issues and how the communication flows go. And coming up from that, it became clear that in fact this was really an everyday issue that everyone, as a people manager in this room, that everyone faces. And it's just a question of luck and chance whether your particular person that you're managing, if it becomes sticky and becomes an issue, whether you're going to be caught out in a situation. All right, and so we actually, after discussing with HR and really discussing with some of the view heads, we thought that this was actually a training session that was really important and long overdue for anyone who is in India who is a people manager, right? And so from that point of view, I just want to introduce the legal team that we have from my external counsel. Vikram Shroff, he is the head of the employment practice here at Nishith Desai, and Ajay Solanki, and they were very helpful to me when we were actually discussing some of our specific issues in the previous case. Gauri Gokhale is really my external lawyer in India that I can't do without. She's here, she helps with all our everyday, from regulatory to clinical issues to compliance issues across the board. So she's the person with whom I work on a daily basis here for India. What I'd like to do is actually, we can either have Thresia do it, or maybe it's easier, every one of you, this will help our lawyers if you just stand up and give a 1-minute introduction to them of sort of the team that you manage, in terms of you manage a team of 3 people, 4 people, and then whether these people are based mainly in which city, which state here, because while a lot of the training today is going to be on sort of common issues, overarching issues, there will be state to state variations. So as they address these issues, it just gives them a sense of how broad a spectrum they have to take into account when they are speaking to you today. So maybe we just start off at the end and just a 30-second introduction of who you are and your team.
So I'm Sumit Anand. I look after the clinical operations for South Asia. In India, we have 3 direct reportees, out of which one is based in New Delhi, one in Mumbai, one in Hyderabad. And apart from that, there are 3 contract employees which we have. All of them are based out of New Delhi. These are contracted to a third-party CRO. And then I have 3 people who are based out of one in Singapore and 2 in Hong Kong. So I guess the contract people which we have, I like to have more details on handling those sort of issues as well.
Contract means a contract labor?
So what we have an
consultants.
We have an arrangement with the third party CRO.
So they're employed with the external agency, or
Yes, they are employed with the external.
Okay, so contract labor. Okay.
Yeah.
We'll cover that.
So it's like we have outsourced a project, and for project-based work, they are based out of our office, utilize our resources in terms of the laptop and everything. But they are on the payroll of the third-party agencies.
Hi, I'm Rahul Sharma, looking after the sales of the EP division for sales. I'm handling a team of 3 to 4 members, and out of them, 3 are based out in Delhi, 1 is based out in Mumbai right now. And also handling a outsourced employee, which is the same like consultants, like the 2 who are based out in Delhi. So I'd like to know more about this.
So these outsourced employees do a different kind of work than your employees?
No, they do the same kind of work. Like
so why have you outsourced them?
To save the cost.
Headcount issues. Headcount issues are a hot political issue as far as the organization structure goes.
Okay, fine. We'll touch upon it. See not to start the session, but outsourced workers were meant to be used for things which were not core or ancillary to the organization. They were not really meant to do the same kind of work that your regular employees do. And this is the biggest mistake that companies make when the answer is I've outsourced them because it's a headcount issue and I didn't want to bear the cost of having one more headcount in my books. So this isn't the reason to use outsourced workers. So at least under Indian law. So
Correct, but you see, when you say that to this group, you're like preaching to the converted because it's not this group that has determined that structure. This structure on ancillary hires are really determined by management that are outside of this group. That's the problem.
So we'll talk to you separately.
Yes.
But probably it's good to know, because for example, my team, I can do that if required. If I have the background knowledge.
Yeah, no, I mean, we're not telling you to change the structure, but
I'm not changing, but probably the work profile of the contracts, I can have a different work profile for them, and then, just to distinguish between the employee and the contract.
At least we'll set the principles.
Then we'll get into the issues on
exactly.
dealing with. There's a separate bucket of issues, I think.
Correct.
So I'm Sanjay, I'm based at Delhi, and main job profile is sales and marketing. My team is comprising of 3 direct reporting manager, also 1 area manager who is reporting directly to me. We are also doing the field managers, 15 field managers, including RMs, and they are based at a different locations: Punjab, Uttar Pradesh, Bhopal.
So reporting to you.
Some of them are reporting directly to me, some are reporting to regional managers, those are reporting to me.
I think it may also help to say whether when there are employees across, whether they are in a specific St. Jude office or they are working out of their own premises, right? Because
So other than Delhi, I'm talking of North, we don't have any other offices in sales.
Yeah.
Sales, I'm talking from sales point of view.
Okay.
So there are headquarters, if I'm saying headquarters Ludhiana, Chandigarh or Jaipur or Bhopal, so we don't have any office.
So does your employment contract say that you work out of Jaipur or whatever
Yes, it is
the locations mentioned?
location.
But we don't have an office there.
Yes, because this main job is field.
Okay. So you are actually officially allowing them to work from Jaipur, but you don't have a commercial office in that city. Just as an example.
I'm Prasad Nair and I'm handling one of the divisions of St. I handle a team of around 14 people who are spread across the country, majorly in the metros. It's Delhi, Bombay, Bangalore, Chennai. I have people reporting to me and people who are reporting to them at Bangalore. Both of them. And most of the locations we have office, except some places where we don't have office.
Yeah, I'm Beno. I've set up a team of 6 people. We have outsourced employees as a contract employees, in fact, contracted under one third party. That piece we have to take care of, and the other things we communicate with various the part of the responsibility, cross-functional communications with within the organizations, with our consultants as well, service providers, vendors. How to communicate. And the one more thing, I don't know whether, because since it is a HR law practice, I don't know whether you become, because our model is 80% is through distributor sales, so 80 to 85, whether the communication through distributor, because that is very critical.
Yes.
So whether you will be covering or not, I'm not sure. So that will help you.
Not in this, but we are happy to answer questions. This was not the intention, sorry. But we can answer those questions as well if we have the time.
Okay, yeah, that's what I said. HR. I'm based out of Hyderabad, and all the team, they're based out of Hyderabad except for one employee, she is based out of Bangalore.
My name is Ajay Singh Chauhan. My team comprises of 61 people. Out of which 10 directly reports to me and rest are reporting to my reportees. They are across the country. So you can say like around 13% of the people are, 35% are in North. There are people in West, 30% in South, and around 10 to 15% people in East. Besides that, I also have a team of service people who are completely outsourced. Like we have how do you put it? Like we have companies which are actually employing people for us in Delhi, in Kolkata, in Bangalore, Hyderabad, Chennai, and Tamil Nadu, right? And we are they are paying the people, but that expense comes to us, and they are doing completely a different job than what the people who are directly who are directly in the organization.
So these
Right.
are
So
more technical reps.
They are technical
They
reps.
provide
So they
service.
technical service.
Yes,
they provide.
and these are people who otherwise might be doing jobs that our distributors would have done, except that as a quality control measure, we took it out of our distributors. We almost direct and manage them, I would
Yes.
say, from the substance of the services that they provide. But they're not employed by us. But yes, to answer the question you asked earlier, they provide different services from what our employees do.
But you're controlling them.
Yes.
You can't get away.
Maybe let's change that word. We don't control them, but we have.
You control their
we-
compensation, their leave, their
No, actually.
travel,
No,
their
no,
benefits.
no. We don't control that. That's all determined by the outfits that employ them. But what we do is
So that is good.
I think
We have now we're adding to the good list.
when I used the word control earlier, it didn't refer to that. It referred to I think the quality of the technical services that they
Which is
provide.
fine.
Yeah, it is that.
That is perfectly alright.
Correct. I did not mean with respect to their employment structure or benefits.
But when these guys get employed for St. Jude but by a third party employer,
Yes.
in their employment contract, do they say they are being employed for St. Jude?
No,
They don't.
should not. I do not believe so.
No, it is Cadillac.
Okay, yeah, they are all Cadillac.
So it is not. We are not having any contract employees in this scenario. It's a agency. We are. It's a third party agency.
I agree, but the agency is not telling their candidates that I am.
Let me put it. In case of contract, I mean a third party agency, it says that you've been deployed at St.
In the contract.
Yeah.
in their offer letter.
Okay,
It's
another
from the
point.
third party agency, but the terms of the contract is that they have been deployed at St. Medical for doing certain work.
But it's almost like an instruction as to where to turn up for work. Isn't
Which
it?
is okay,
Yeah,
but
which is fine.
how critical is it for the contract to mention that they are being deployed to St. Jude offices? Can it be that they would be deployed to clients of the vendor as may be informed from time to time? Can it be broader? Because I don't want it to
So
sound
let's
as
take
if
that. Let's take that as an actionable item
Yeah,
at the end of this discussion, because what we're describing to is the current situation, and
Yes.
certainly what we hope to get out of today is things that we can improve to manage our risk on this front.
And one more critical bit of information is that most of these agencies are doing work only from St. Jude Medical. They don't have.
Acha, oh.
So that
fully
is also-
dependent on St. Jude.
Yes. So that is I think that really important information.
That's in terms of the service.
Service, yeah. In terms of my division, my this thing I'm telling you.
Yeah, no, that's fine. We
So
understand.
you can
Also,
add
the
that to the
interview
high-risk
process
list.
is being done by.
Yes, like when they hire, one round of interview is done by our managers before they hire.
Hi, myself Usri. I'm regional manager for Side Division. I'm based in Hyderabad. I have a team of 8 members. From there, 3 out of 8 trees are in Kolkata and 3 are in Delhi. 1 in Hyderabad and 1 in Chennai.
Okay, we are just lawyers, so we want to understand the phrases like SI and all of that.
Okay. So this is another division. Structural heart.
It's a sales. I'm Anand Ghosh. I take care of the IT function. I do not have any direct reporting, but all my functional activities are managed through the outsource vendor whom we have engaged, and they have deployed their resources in our premises, which is in Hyderabad, to carry on different IT related.
So are these under the, you got a registration under the Contract Labor Act to deploy? You have, okay, so that's good.
Good afternoon, I'm Satya Sundar. I'm business head for Structural Heart, the new division, which consists of the cardiac surgery business and the structural intervention business. The total number of employees would be 36 in this. So till now I was having a direct reportees of 14 people. Now I will have like 7 people like directly reporting to me. Right? Spread across like India and India. Like I'm in charge for Indian subcontinent, but then all the employees are in India.
Correct.
I am Arif Fahim. I'm in charge for therapy development and health economics and reimbursement for India and Southeast Asia. We don't have any employees in Southeast Asia, only in India. We have 4 employees. So 3 of them are contracted consultants. That's what I could gather from the discussion, if that's how I define them. And one of them is a director. And these are project-specific roles. So, people are assigned to specific projects that they are working on pretty much exclusively.
Hi, I'm Vijay Kumar and I lead supply chain for Legacy Central Medical. And I have direct reportees and the overall team size is 5 on the payroll of Legacy SDM and 3 temp guys outsourced to on the payroll of the third party. And everyone is based out of Hyderabad except me. I'm based out of Mumbai.
Hi, I'm Munich, and I take care of marketing for East and West India. As of now, I don't have a direct.
You're safe.
I'm safe.
Hello, I am Shreya Paul, and I take care of the human resources operations for India. And as I have 2 direct reportees, both of them based out of Hyderabad. Overall, I look after the 130 employees who are spread across the country.
Okay. So thank you, and a bit about me. I head the employment law practice at Nishith Desai Associates. I've been with the firm for over 18 years, and at some point in time, and in relation to the subject of today's session, somewhere after the subprime crisis of 2008, the kind of matters we started getting on employment termination, downsizing, reduction in force, lawsuits as in legal notices challenging the termination. So at some point in time I was unofficially called the in-house terminator at this firm because I just got associated with any matter that had some element of termination involved in it. So as Nicolas said, this is obviously a session for learning, but I'd like to sort of put in a disclaimer that you never completely learn this subject. It is so open-ended, and every matter that we get is special, unique, different in its own ways, and you can never. It's always which way to go, this way or that way. It doesn't normally work only from a legal perspective. You have to take into account a lot of practical realities because you're dealing with employees on the other hand as compared to other areas. So this is something that you'll always keep learning. It's an ongoing process, and to that extent, keep your minds open in terms of things. There may not be really any right or wrong answers in some situations, and it's a call that you have to take on how you want to go about with it.
So just to introduce myself, I am Ajay Singh Solanki. I have been working with the HR laws practice for almost about more than 8 years now, and it has been a great experience working with respect to this particular niche area of practice. Obviously, a lot of work comes through in terms of not just termination of employment, but other things like hiring people and working on contracts which are varied in nature, which have a lot of structuring involved in terms of secondments and other things. So today, as we are going to discuss the termination of employment bit, obviously we'll focus on that area per se. You need to start.
Okay, we are starting with a question, which is: Does India recognize actual employment? At will means hire and fire at will, and this is obviously a terminology that is popular globally. And just wanted your thoughts on what would your answer be if such a question.
Just for an example, so this would this be something that is possible in India per se?
Yeah, so coming back to the question, does India recognize at will employment? Anyone? No. Obviously, it's no, because if that was the case, we would probably be out of business here. We would be doing maybe M&A or something else and not employment. I mean, as I said, a lot of matters revolve around termination, and unfortunately, there are times when we get a call from either HR or legal department to say that we've received this legal notice from the employee's lawyer. Can you help us? And I asked that what happened, and they said, well, this employee stopped coming, and therefore we issued the termination notice about 1 month back, and now we've got this legal notice. What do we do? So my answer is, well, if you had just called me 1 month earlier, prior to issuing the termination notice, things would have been slightly different. We could have worked towards it. Now, obviously, there are limitations in terms of how much backend stuff we can create, and obviously that's not possible in an employment scenario. So you just have to be careful in terms of all your action. And talking of at will, it's a mode of a relationship that is legally permissible only in the US, in most states. In India, or for that matter any other country in the world, there is no at will employment system. You cannot fire at will. There has to be a reason or a cause to terminate employment. And again, each country has its own way of sort of dealing with those situations.
Can I ask a question?
Yes, please.
So in this scenario, is it appropriate to keep normally in the appointment letter we say that your appointment can be terminated at any point of time without assigning any reasons. The employer can terminate your employment without assigning any reasons. So is it correct to mention that in the appointment letter?
And what would your answer be?
Ideally, as per this, no.
That's correct. See, whatever you write in the employment contract doesn't matter. There are laws protecting employees, and to that extent, if a law provides a certain level of protection, your provision of the employment contract can be disregarded for all purposes. I mean, you're not really going to go on and write in your employment contract that you can terminate only for cause or for misconduct, right? You won't really do that. And you would hope that the provision that you already have in your existing offer letter is something that is accepted by the employee, and the fact that the employee doesn't know what the law is or the protection under the law, and probably you might get away with it. But at the end of the day, if he knows the law, or if he has his uncle who's a lawyer, it's going to be a pretty easy giveaway to say that it doesn't really matter what the employment contract says. You will have to go down in terms of what the laws are and what kind of protection you have under those laws. So, so we can only terminate for reasonable cause or misconduct. That is a sort of general rule or a theme, and then there are different categories of employees: workmen, non-workmen, managerial, and those kind of things, which we will go into in this session. But this is a broad level principle or a thumb rule that in India you can only terminate for reasonable cause or for misconduct. Even though US is at will employment, which means you can terminate at will, you see greater number of cases on employment termination in the US, and with far higher stakes in terms of what the quantum could be if the termination is found wrongful. Why would that happen? I mean, if US law allows the employer to terminate employment at will, as in without a reason, why do you see so much of litigation in the US surrounding employment termination?
There may be some clauses for that at will employment.
If the employee can prove that the employer has misbehaved or misconduct in
termination.
Nullified intention type of situation.
But it's at will. So in US, right, you can terminate at will. Whether or not you have the intention, how does it matter? It's at will. At the employer's will.
So the stakes are not about termination. It will be
Mental
other things
health,
which will come into play there.
Very good.
It's not
What are those other things? You're right.
Employee rights for the employee.
What kind of rights? You're very close to it.
So just a clue, I think. Can you? I'll just give a clue.
Sorry?
Financial security.
Just a clue. So somebody says that, okay, I don't like your face. You are fired.
this racial.
Yeah, that's correct. So okay, so that's the point. So in US, even though there is at will, there are laws in relation to discrimination. And discrimination could be really extended. Your color of your skin, or your origin, or your sexual preference, or your age, or your caste, or anything. Anything and everything is protected. So here you are an employee, you got terminated because it's at will. Your employee will come back and say, well, you discriminated because I was an Asian, or I had black skin, or I was above 50 years of age. And then the employer has to prove as to why he was not discriminated, and the whole process will taken, and will go into litigation where the employee will have to demonstrate that equal parameters were applied in terms of consideration, and this was not a parameter. So any country, I think the point I'm trying to make is that in any country, termination is as stringent as possible, including in the US where they have an at will. So just you understand, in India you don't have those extended protection on discrimination, unlike you have in the US. But then you already have laws on for cause and for misconduct. So that's where you don't really need those kind of laws, which in a way is actually good. Okay, so we have laws, and we have several laws. As you know, we have close to 150 laws, both at central and state level, and that keeps us going actually. I mean, just to even understand that these kind of laws exist, forget what the laws say. So you have laws on labor and employment, close to 150 across India. If you look at a company that's having multiple kind of operations like the Tata Group and having offices across India, they probably have to end up complying with close to 150 labor laws. Okay, so obviously that, and that's why we can charge a lot of fees, so makes it easier for us to convince our client that pay us more. So you have, and again, these are laws only in relation to employment termination, so we are not really going into the other labor laws. But basically your foremost law is called the Industrial Disputes Act. It's a central level law, and I'm sure you heard of that in news articles or otherwise. Which law applies only to employees who are categorized as workmen. Okay, this law applies only to workmen. Now, do you believe a company like St. Jude would have workmen? I mean, right? You're talking about a 1947 law which had obviously a pre-technology age. It was only factories and mines and plantation units and all of that. A law drafted there which said that it applies only to workmen. Do you think it could apply to?
Yes, especially when people are working out of office, where you don't have a establishment like people are working in Jaipur, where St. does not have a. They can be actually classified as
workmen.
Workmen, what is the definition in workmen? Like the person who is
skilled or unskilled is.
Can you just go on to the definition? Now that you asked that question, we were planning to cover it later, but no, next one. This is the definition. Okay, I mean it's a bit of a reading, but I'll give you a minute. I'm not going to read it out, but after reading this, I would like your views on whether you believe St. Jude would have workmen at its office. So Ajay said it was only those who are outside office. What about the guys in office? There are two important exceptions who's employed mainly in a managerial or administrative capacity, and fourth one is the one who's employed in a supervisory capacity drawing wages exceeding 10,000. So
why
so
do
now
the
coming,
law firms have such a difficult definition to generate?
so that lawyers can charge more fees. Well, I mean, you have to appreciate that it's very difficult to define who is a workman, right? I mean, and in 1947, people who wrote more obviously got more money in terms of drafting laws. So, but okay, so does it change your answer now in any way? That do you think St. Jude would have workmen?
Yes.
Yes, yeah, correct, right? Because if you see the definition, any manual, unskilled, skilled, technical, operational, clerical or supervisory work for hire or reward, right? It is really a lot of points there to cover who's a workman. So technical, right? Anyone can be doing technical work. Anyone, a skilled employee is a workman. The only exceptions are one who's in a manager or administrative capacity, and second who's purely in a supervisory capacity. Now you have to extend these exclusions in a factory scenario, right? You can figure out who's a supervisor by seeing that there is one guy who's seeing another 10 guys doing the work at the floor. He's not doing anything. He's just watching those guys do their work, right? In today's sort of industry, you don't see those kind of people, right? Everyone is doing their work and then they are supervising. It's a mix and match kind of a thing. You don't have pure supervisors. So honestly, and except keeping you guys outside, everyone else in your organization may just end up being a workman. And that's how you want to treat, when you're dealing with those situations. Start off on the context that he may be a workman. It's better to take a liberal view in that case, that he may be a workman and accordingly protected under the provisions of the Industrial Disputes Act, and how do I deal with that kind of a scenario. So
but if he's drawing salary more than 10,000 rupees, does also then also will or he or she will be workman.
And what's your answer?
As per this definition.
So anyone who gets more than 10,000 is not a workman? You'll give everyone 11,000 and say I have no workmen. You're correct. It's basically for anyone who's in a supervisory capacity, and in today's world, honestly, who's in a supervisory capacity, I have my doubts, right? You'll never be able to figure out that this person is not doing nothing but working in a supervisory capacity.
At one point, even the company started recruiting us like managers, like for territory, earlier it was territory sales representative. They started calling them territory sales manager.
Okay, does that change?
I don't know, that's what the intention of the companies.
No, but that's not a supervisory role as such.
No, but then look at the third point, right? He's got a very good point. One exclusion is who's employed mainly in a managerial or administrative capacity. So let's say there is a peon in the organization, and you said that housekeeping manager. Okay, you called him that, right? You just changed his title. How good is that?
Job remains same.
The nature of job is same here.
Exactly. So and there have been umpteen cases where courts have said disregard the title or the designation. It's got no relevance. Go into the nature of duties and responsibilities, and more importantly, go into the nature of authority vested upon that person to determine whether he occupies a managerial skill or not. In terms of at the organization, you have to relate it with other managers. So, what kind of authority he has? Does he have authority to hire and fire? Does he have authority to bind the employer by signing contracts? Does he have authority to sanction leave? Does he have authority to conduct performance evaluations and make recommendations? All of those things will go into determining whether he has a managerial authority in the true sense or not. And if he does not, the title really doesn't matter. So that is what it is. We'll come back to our earlier part actually on the laws. So this is Industrial Disputes Act, which applies only to workmen. You have the Industrial Employment Standing Orders Act. Again, this was not meant to apply to commercial establishments, but certain states, including Maharashtra, have extended this to commercial establishments. Again, Standing Orders Act has certain provisions in the Model Standing Orders on employment termination. Then you have the State Specific Shops and Establishments Act, which would basically apply to all your offices across India. And I'm assuming you got a registration under the Shops and Establishments Act. And each and every Shops and Establishments Act has provisions on employment termination. I don't know if you're familiar with it, but every one has, how the employer can go about terminating employees, what are the employees' rights, and if there is any limitation in case of an illegal termination. So it's all there under the Shops and Establishments Act. So you'll have registrations under the Maharashtra Shops and Establishments Act, Karnataka Shops and Establishments Act, Delhi Shops.
So we have three actually: Maharashtra, AP, and Delhi.
And Hyderabad?
No other office. We don't have an office in Kolkata and Bangalore.
Hyderabad?
Yeah, it's not.
Okay.
So only 3 registrations you have. So you don't have offices in any other. Okay. So then there are distributors or staffing services agency employees.
So the third party agency who we engage, they are based out of Hyderabad anyway. So the distributors are I don't know, they're all they have.
But others, I think the field force is basically operating out of their own houses or whatever. I mean, there is no physical premise of St. Jude
So
in
we
those
have only
organizations.
3 offices across
Which is
the
fine. See, what would happen is you cannot get a Shops and Establishments Act registration unless you have a physical office space, right? Because you have to give a copy of the lease, and it is for that establishment, physical establishment, for which the registration is
For
obtained.
this reason, we have only 3.
Which, so you're correct, that's fine. But then when you go into your offer letter and say that you are going to be working from Jaipur and you don't have an establishment registration there, the question that arises is that will he be subjected to the laws of state-specific laws of Rajasthan, or will he be subjected to the state-specific labor laws of Delhi or wherever your headquarters are, where the offer letter has been issued? So you'll get into that particular
So the
question.
offer letter is issued on the letterhead of Hyderabad, which is the corporate office.
Correct.
Though the employee is based
But you
on-
recognize in your contract that he has to work from Jaipur, right?
Right.
And if you recognize that, the question then arises is that what is...
But the location can also change during the service time.
Yeah. So employment is transferable.
But that contract is not getting changed.
Yeah, the
No, so
location
whenever
will
there
change.
are transfers, there is a communication to them.
Yeah.
So that will be treated as an annex to that.
Amendment to the contract.
So just to clarify the Shops and Establishment Act, the point that Vikram mentioned about workmen versus non-workmen. So the non-workmen still have the protection under the Shops and Establishment Acts under the relevant termination provisions. So thought I'll just clarify that.
No, that's a good point. The only thing is that some Shops and Establishments Act have a exclusion for managers. Somebody who's occupying a managerial position, and a couple of them go on to say, and has overall control over the affairs of the establishment. Right? So we don't know who that is, but it can't be a whole organization, obviously. It'll have to be a very... In Bombay, previously, there was a provision that not more than 10% of your total workforce cannot be managers as well. So they had a limit, they did away with that limit. But the intention still exists that you can't have an organization where 90% of your workforce is managers, right? That cannot be the case. So irrespective of title. So we'll have to apply that. We've actually done this exercise for some of our clients to determine where we draw the line in terms of managers versus non-managers. So we've gone into great extent to determine where that distinction applies.
Excuse me, how do you define manager in this case?
Like I said, like the kind of authority that he has.
So that's subject to interpretation.
Oh yeah, it is subject. There is no definition under the Shops and Establishments Act as to who is a manager or who occupies managerial position.
So the biggest
So
amount
it is
of
purely
litigation-
subjective.
Yeah. The most amount of litigation is on the fact whether a person was a manager or not, because of the fact that the kind of rights that the employee would have would be determined, because for a workman there are greater amount of rights as envisaged under the Industrial Disputes Act. But the first preliminary point that the employee usually raises in an employment litigation is that he was a workman, so that he gets more rights. But obviously from the employer's side, you need to provide that kind of proof that, okay, his duties were this, his obligations were like this and all that, so that you can prove that he was not a workman. And it's subjective.
Yeah, every case law is the first question is whether he's a workman or not, and that will itself take you 2-3 years, in the courts to figure out one way or the other. And if he's a workman, then this is what it is, and if he's not a workman, this is what it is. There are cases where, classical case, sales employees. There are sales employees who've been called workmen, and there are sales employees who've been called non-workmen. So as you rightly said, it is so factual and so case specific that you can never say for sure. And we as lawyers try and resist giving a clear view to the client, because we also can't, that whether this person is a workman or not. We have to be very careful in how we structure our response so that the client doesn't come
The
back.
reason why this becomes very relevant is to how are you going to do the right, it's not only the termination that we are talking about, right? The performance evaluation, the notings, everything leading to a certain thing. So we have honestly seen situations where there is a performance evaluation of at a certain level, and then termination leading to within 1 month of performance evaluation. So I think we'll cover those situations, but the reason it becomes relevant is because under the Industrial Disputes Act, the protection is at a much higher threshold than under the Shops and Establishments. So it is very important to understand where your team can be sort of blocked. For example, if you are say having, some of you mentioned that I have 7 direct reportees and some 15 other indirect, whatever. So the people who are say direct reportees, we could probably still consider they are excluded from the disputes act. We need to know their role. But those below them, they obviously are they are not managing anybody else's business but of their own, right? So it's very important for you to understand what is your team comprising of, whether they are workmen or non-workmen, because the entire flow of their communication and everything will have to be structured in a particular manner, so that some of the issues that we will deal with don't get actually escalated at the termination level. So
And yeah, just to add, you could be a workman today, or when you joined and you're no longer a workman 5 years later, because of the nature of your duties kept changing, you have more authority vested upon you and things like that. In fact, as an example, we had this situation for a technology company client of ours, where the employee had and we thought he was in a managerial position, so not a workman. He had 5 reportees, and he was sort of taking their PE and authorizing leave and all of that kind of thing. So he had decent amount of authority, and we could sort of take a view that yes, he doesn't appear to be a workman. But what the client did was that, because he got into some issue or was not performing well or something like that, the client demoted him from that position to a lower position, where he no longer had these people reporting to him. They had some new manager and all of that. And then after 1 month of demoting him, they decided to terminate. And we were like, well, if you had done it 1 month earlier, he would have been not a workman, and he would have been in a better position. And now you are doing this after 1 month after demoting. You already sort of hit a nail on your foot by doing this. If you had done it earlier than later, things would have been different in this kind of a case. But that's life, right? I mean, the client didn't really know. So just as a learning, just figure out the sequence of events in terms of how you want to go about with it. And if it's termination and then you're going to do something drastic like this, you obviously will be in some sort of another issue. There are laws in certain states, like the Maharashtra Recognition of Trade Unions and Prevention of Unfair Labour Practices Act, which basically talk about what are unfair labour practices on the part of the employer. And again, it's a fairly long list. Typically, again, deals with unions, and I believe we don't have unions, so we are not really getting into those discussions. But there are some of them. For example, if you take a regular employee out and replace him with a contract worker, doing the same kind of work, it could be an unfair labor practice on the part of the employer. So just to keep that in mind, in terms of the points we discussed about what your contract workers are doing.
Can we ask the AC to like
Oh yeah, you're right. I didn't see that. It's definitely not working. Okay, then there are again. So then brings us to your point about termination provisions in your employment contract, in your employee handbook, code of conduct, HR policies, and all of that, right? Now, in your employment contract, you probably have a clause that says that either party can terminate by giving 1 month's notice, or whatever that notice is. I don't know, what is it, 1 month, 2 months? 2 month notice. So either party can terminate employment for by giving 2 months notice or pay in lieu thereof. Is that good enough from a labor law perspective, especially when you're dealing with an employee who is protected under these laws? Answer is no, right? We've discussed that in the past. It's not good enough. So as managers, don't just go and say that, well, this is what your employment contract said and therefore I'm terminating you, and the HR will pay you in lieu of notice and matter ends. That doesn't work. But and again, when we go into the labor law provisions, you'll know why, but just to sort of answer that question, that's not good enough. Yeah, so obviously a nice way of saying that you are no longer part of the system. Okay, so now going into the core part of our session. This might appear a bit boring, but that's how life is. Termination of employment could be employee initiated, employer initiated, mutual separation as in both parties agree, or others. So employee initiated is nothing but a resignation. So the employee comes and says he wants to resign. We are like, okay, well that's fine. I mean, we try to keep you, but I guess that's a decision, which is fine, safe, and most would eventually resign. That's how it sort of works out on a practical basis. The other is an employer initiated. So either it's a stigmatic termination, which is basically misconduct, that you're casting a stigma on the employee to say that I'm terminating you because you damaged my property or you were involved in some form of harassment or something as grave as that, and therefore you're terminated. That is again how you treat. And the other one is termination simpliciter, which is nothing but termination for reasonable cause. Thankfully for lawyers, none of this is defined, so it's obviously something that we'll have to look at on a case by case basis, whether a particular incident could amount to misconduct or it could amount to reasonable cause. And then there are different processes that need to be followed depending on what kind of termination it's going to be.
I would just add, in employer initiative, we have often seen situations where it is forced resignation, and we actually had situations where there was a discussion with the manager, and the manager sort of asked him that either you resign or we are in any case going to terminate you. And we have had situations where, in fact, after resignation, then the employer raises a claim saying that though I have resigned, it was something which was forced upon me, and challenged challenged his own resignation process. So that is one more situation we have seen come up, and especially when typically what happens is the managers or the HR team or whoever, they feel that if I do some, as Vikram said, it's some stigma likely to be imposed or otherwise, which you don't want that employee to suffer in his next employment. You sometimes take a humanitarian approach to say that okay, let him resign, right? However, if the paperwork insofar as the back end is not appropriately done, whether his performance or otherwise, if at all he comes to challenge that, then you don't have a backup to counter his allegations. So therefore, even if it is forced resignation, one needs to remember that that is not always a necessarily safe approach in certain situations.
Yeah, especially just to add there, in case of misconduct, now as Gauri was suggesting that at times you take a more humanitarian approach and you basically offer the employee to resign. There may be a flip side to it, as she also mentioned, that the employee may tomorrow file a case saying that okay, they were supposed to terminate me for misconduct, because misconduct requires an entire procedure to be followed by the employer, and he may say that the employer never followed that procedure and therefore my termination in itself is invalid, or I was forced to resign and it was supposed to be for misconduct or something, and therefore I should be reinstated. So we have to really take that decision whether we should actually offer the employee that kind of option.
So I would say majority of the cases would eventually be documented as resignation, whatever the reason be, either it's termination for cause, misconduct, or whatever it is. Eventually, and as a sort of takeaway from the session, you try and encourage or incentivize your employee to resign to reduce the legal exposure. Obviously, if he's done something dramatic like sexual harassment or something like that, and you want to sort of show it as a deterrent to your other employees, you might want to terminate. But other than that, there is really no objective that you're trying to achieve by terminating. You would rather get him to resign and close the matter and move on in life, because it's not just from our perspective that we are saving ourselves from litigation, but also from the employee's perspective, where tomorrow if he wants to look out for a job and if the future employer gets to know that he was terminated, it's going to be looked at very differently by him. And in most cases it ends up being a win-win situation when the document says a resignation rather than a termination.
And with the non-performance will be considered as a reasonable cause, or it's a reasonable cause?
We've covered it later, so I'm not going to. Yeah, then there is mutual separation, which is something which we do for senior level situations where it's neither a resignation nor a termination, it's mutual separation. This remains largely untested in Indian courts, so we don't really know how Indian courts are going to look at it. But it's something that we have been sort of following for senior level positions in terms of.
Is this a kind of like non-renewal of contract or something?
No, I'm still coming to it.
So even in mutual separation, he can come back and say that like it was a forced one.
Yes.
You can always contest for us.
We have a situation in one of the uh, biggest, most valued companies of the world right now, where the employee has signed a mutual separation agreement, and then she sent a mail to the management in the US saying that she was forced to resign or forced to sign it, and she wants to know the reason why. So we are dealing with that kind of a situation. Other forms of separation, retirement or superannuation. So do you have a retirement age in your employment contract? I believe so. So if you reach whatever it is, 60 or 65, something like that, employment termination, so that's one. And to your question, we have in certain cases used what we call fixed term employment contracts. And at the end of the fixed term, the employment ceases, and it's neither a resignation nor a termination. Now, if it was that easy, why would not all contracts be on a fixed term basis? Anyone wants to take a shot at that question? I mean, why not have everyone on a fixed term of, let's say, 5 years, and then at end of 5 years figure out what they want to do, or the employment? Why get into all this employment termination and those kind of issues? If you want, after 5 years we renew for another 5 years, but why not do it? So why don't you see fixed term employment contracts being used more often in the country? Anyone would like to take a shot? And people are online, right? I mean, there are people on phone as well, right? So if they want to react as well, happy to.
No, whether it is a fixed term employment, whether all the benefits which are given by the government side are actually whether it will be applicable or not, or be
Yeah.
considered as a consultant or a retainer type of
No, fixed term employment contract. So it will be an employment relationship. This is different from those
employee-employer
consultants.
relationship.
But for a fixed term.
It's like a short service commission in army also, 5 years, 7 years.
Yeah, why don't we have that in like St. Jude or in the pharma sector or any other sector as such? Why don't you see fixed term contracts? And why 5 years? Why not like every 1 year or every 6 months or every month keep renewing? Why don't you see those kind of contracts?
Because you can't have the retained people. They keep changing.
Maybe government has put some limits to higher percentage of contractual.
Some specialized services, someone if is tendering, then it could be with a fixed term employment.
It could be.
It could be.
Close. Okay. Would HR would like to react to why not a fixed term? Why are all these employees not on a fixed term contract?
So, not really. So, the point that they mentioned, and then the service years, the experience that employee has, your benefits, and in fixed term, there are fixed salary, right? And there are terms in the fixed term. I'm not much aware of fixed terms.
So see, the fixed term contracts were meant to be used for projects which were had a similar duration. You can't just use fixed term for an ongoing employment relationship. So if you're getting an employee for a particular project which is meant for, let's say, a year, and you're getting him only for that project and saying that you are hereby being employed for this project, the duration of which is expected to be about 1 year, and accordingly your term is only for 1 year, that's fine. But otherwise, in an ongoing employment relationship, you will never be able to justify why a person was taken on a fixed term relationship, except for the fact that I didn't want to comply with the termination provisions, which obviously no court is going to accept. So that is where fixed term contracts are not really very commonly used. But where you can justify the need for a fixed term, then it would work beautifully. So.
But then, is it possible that I engage a person for a fixed term for 2 years for a project, and then the project gets extended?
Genuine situations we can see.
Yeah, but if it is, say, extending for years together, say for example 10 years together, then the courts are obviously going to take that stand that he was not a fixed term employee. Because usually the way it happens is the Industrial Disputes Act in fact has a definition of termination / what is called retrenchment under the Indian laws. Their fixed term contracts are specifically excluded from that definition, so people would have taken advantage of it in any case. So courts obviously are mindful of that, and they if these are the kind of cases where it is getting renewed on and on for year and year altogether, then in that case courts are obviously going to go into the intent of it and say that it was not a fixed term employment.
I have a question. So, in case of third-party consultants, does the same logic apply, or you could still renew the contract with the consultant year over year, or whenever the fixed term completes? But the employment relationship with the particular employee and the consultant.
The same would apply. Yeah, you're correct. So the agency who's hiring on your behalf, the same considerations would apply to the agency as well.
But then the third party agency, there's no end date, right? There's no end date to my employment with the company. Similarly, when I engage a person for St. Jude through a third party, there's no end date to the contract. There's no end date to the employment.
That's correct.
So, no, but there can be an end date. So that's
No, between you and that contracting company, there can be an end date.
Exactly.
And there can be a renewal and all of that.
Yeah.
But however, as between that company and the employee, who's could be, who's actually working for St. Jude, then that is a separate issue. But again, whether that that company is providing you the service, or whether that employee is providing you the service, whether it's a contract labor or really a contract for service by the company, that those are completely different legal issues that one has to look into. So I don't think we should spend time on that right this stage. The short point is, as between you and the company, yes, there can be fixed term or whatever it is. But we have had these situations where the employees are actually working for the main company, but it's only for whatever reasons it is they are being employed by this third party, and everything right from hiring to performance management, everything is managed by the main company. Then the question arises whether the contract labor law applies in that case and what are the compliances, and if there are no compliances undertaken, then that employee is actually treated as employee of the main company. So those are completely different consequences, triggers that one has to look into. So I don't think we need to get into that regime right now, but just wanted to clarify these two different provisions.
Yeah, but just point there that today we believe that some of these staffing agencies like Team Lease, Manpower, Adecco, and lots of them, I mean these are the big ones, they are said to be the largest employers in the country. And everyone is now using this model more and more and more, kind of a thing. Team Lease's IPO, which was the first Indian company in staffing services business that went public, their IPO was oversubscribed 74 times. So it just shows the kind of interest that the country has in terms of this as a business model. Nobody really wants to take on the sort of employee on their roles issue kind of a thing and then deal with termination and get into lawsuits and all of that kind of thing. So more and more people are using this model, but there are laws that, like the Contract Labour Act, which sort of governs the relationship in that situation. Ajay, you want to take this up?
Yeah. So what we'll do is we'll quickly go through most of these modes of cessation of employment that we just discussed. So what we'll do is we'll categorize them into three parts. What exactly is the mode of separation, then what is the documentation that should be taken care of. That would be the most important bit, because that is what would be something that would form a part of your proof or evidence on record when these cases are challenged in courts. And lastly, what are the financial obligations that an employer needs to take care of in case of each of the modes. So when we come to resignation, as we rightly know that resignation would be something that would be voluntarily coming from the employee. But what is more important is in terms of documentation. Now, you would want the employee to write a resignation letter to you, or maybe a resignation email to you at least, which will document the resignation. The other bit which usually employers forget, or which usually managers also forget, is with respect to accepting or not accepting that resignation. Because there have been umpteen number of cases in the courts where people have said that I had resigned, but on the very next day I rescinded my resignation, I took back my resignation, and therefore I am still an employee of the company because the employer or my manager never accepted my resignation. So the second bit is importance of accepting the resignation. And lastly, there can be one more document, or maybe we can add some language to the acceptance itself, which would say that these would, as in reminding the employee of any post-termination obligations which the employee may have in terms of, say, a non-solicitation, post-termination, or non-compete, which whatever we need to put in there. So that is something that can also be used. Now, in terms of financial obligations, all accrued.
So sorry. So just on the importance of, again, there is no provision under law where the employer has to accept the resignation. But I think it's a good practice to accept the resignation because there have been cases where employees have tried to withdraw their resignation, for some reason. In fact, there have also been cases where they have withdrawn after resignation was accepted. But let's not go into that. But the moment you get a resignation email or letter, and if you're really fine with it, just simply go ahead and accept it, right? That it's accept. So at least you're closing the loop from that perspective rather than leaving it open-ended. And if you don't do it, tell the HR to do it. But ensure that somebody does it so that you've closed that loop and potentially eliminated a possibility of withdrawal of the resignation.
Yeah. So, financial.
Sorry, even if you don't have a last date in mind, say your resignation is hereby accepted, we will let you know what the last date is, or we'll come back to you on the last date or something. But just close the loop,
And as I said, obviously,
is it possible that the employee resigned and then he withdrew?
Yeah.
And thereafter, the employer can ask him to terminate it.
Yeah. I mean, we'll come separately on termination. How do you go about termination? But it's possible. I mean, that can't be the reason to terminate, that you withdraw your resignation. There has to be other reasons. So we'll come to that.
Yeah, those may be cases where the employee would have been given an option, and then he had a change of mind, and then eventually took back the resignation. So then, if we had good reasons for termination, then we would go ahead and terminate that. So coming to financial obligations, and so basically, you would have all accrued and unpaid wages. You have payment of wages in lieu of any accrued or unpaid leave. So this is something which forms a part of your FNF, the full and final settlement. Gratuity, if it is applicable in case of the employee. And lastly, you have any contractual dues. Gratuity, as everybody would be aware, would be applicable in a case where an employee has completed 5 years of continuous service, and in that case, if the employment is ceasing.
There's nobody from finance here, right?
Yeah.
How do you go about paying gratuity? Is it 4 years,
No,
8
5
months?
years. It's 5 years.
You kept 5 years. I mean, there is a possible interpretation of 4 years, 8 months, but we typically don't agree with that interpretation. So
And subsequent after 5 years, so above 6 months, it considers a one completed year service. So if we complete 5 years, 7 months,
then it's
it will be
6 years.
6 years.
Yeah. But not 4 years, 7 months.
No.
You're not treated as
They are more employee friendly. 5 years, 7 months means we will give 6 months. Sorry, 6 years.
No, that is as per law. That is fine. But what happens if 4 years, 7 months? You're not paying 4 years.
It's 5 years completed.
How with the incentives part? How do we cover on that? I think for some people, for
contractual dues. Those would be all contractual dues. So anything that is
No,
not.
but then there is a clause in the incentive that he has to be on service at the time.
So that's the contractual bit. So basically, if it says if you were in employment, or if you're not in employment, or if you are in notice period, then you won't be eligible. That's all contractual that the employee has agreed with the employer. So
the employee is not required to pay those dues.
Yeah,
if it's contractual,
if
I mean,
contract.
so see, there is bonus under law, like the payment of bonus, like there is a statutory bonus.
Yeah.
But only certain employees can get statutory bonus, and then there is contractual bonus, which is over and above law.
Probably I'll refer it as an incentive. What we have in
Performance
related incentive.
That is contractual.
That's contractual.
That would be contractual.
See, there are two situations when you say, when you say contractual. One is something which is entitlement basis certain performance parameters, and something which is discretionary, right? So there also, if at the end of the whatever period, if there is a performance-based incentive where the performance is proven, documented, acknowledged, then that is a due that gets crystallized, correct? Something which you will say that end of the year we will see your overall performance, which is not, I'm not talking about statutory bonus, but more like a discretionary bonus, there, it's something which if you believe that a person has not performed, which you won't give him.
So, for example, for the support staff, the performance bonus or the annual incentive we have is not linked to the performance of the employee.
That's exactly the point, right? So if it is nothing to do with the performance, then contractually it gets crystallized upon having completion of a say period or whatever it may be.
Completion of the period.
Correct. So therefore,
So it's time-based.
Yeah. So it is simply basis some contingencies or identified milestones. So that's a contractual thing which gets crystallized upon happening of that event, which is identified. Whereas discretionary, we have several times get this situation that contract is drafted in a way you can't really figure out is it contractual or is it discretionary. So it is important to identify what is discretionary and what is contractual upon happening of an event.
But in our case, what happens? Say annual performance incentive, which is paid, say at the end of the year, right? So as per the whatever the performance factors, whatever the this one, and if those performance not individual, the company performance, and they have been met, right? And there is another clause in saying that. So suppose if we distribute say that the performance bonus in March, but he leave the company or we terminate say in Feb itself. So we have clause saying that on the date of distribution of the bonus or incentive, he should be there in the employment. So what the law says, because he may argue saying that Jan to December that performance is achieved. For that period I was in the roles, though on the distribution date I am not there. So what is the state?
It depends on the way it is drafted. You just want to explain.
So there's no law. It is what you put in your incentive program or plan document. If the document says that you have to remain in employment and in good standing and not serving a notice period as of the date of distribution of that incentive, and if he is serving a notice period or if he is resigned, then our view would be that he is not entitled to it because it's purely as per contract.
So he can contest that like you are delaying the disbursement. He can say.
Yeah.
I don't know if you commit to when you will pay that amount, right?
Termination, people don't leave 25 of it.
So there's an option.
Once they confirm, these are status, then they put the paper.
Bonus and gratuity are their biggest concerns. Will I get my gratuity and will I get my bonus? That's the biggest concern.
So we covered this.
And one more thing regarding since the gratuity, because before I forget, so say it is practical right now, which is happening. This is an acquisition, right? They take over by the employees, they move to the other legal entity. So whether it will be considered as a continuation of service for gratuity purpose, right? Though there is change in the legal entity as
it will be. It will be an employee transfer.
Okay.
And transfer has to be on a continuous basis without any interruption.
Yeah. Okay.
So we covered this, but we want to start with this because of the fact that we, when we talk of employer-initiated termination, where we say that any reasonable cause is required, that particular part is first of all covered within the Industrial Disputes Act, and the Industrial Disputes Act applies only to workmen. So here, what we've done is we've tried to list out a couple of reasons that have been upheld by the courts as reasonable cause, obviously based on the proof or evidence that would have been provided by the employer to the courts. So one is poor performance, the second is redundancy of the job, and third is loss of confidence in employees' ability. So these are only examples which would be relating to reasonable cause. These would obviously require robust documentation to defend our case, whether it was actually poor performance. So in that case, obviously your performance evaluation reports and all. And as Gauri mentioned, one of those cases where you cannot have a person who to whom you gave a 5-star rating or an A rating, and the next month you terminate him or her. So that makes your case really weak. The second is redundancy. Now, redundancy is something where
let us spend some time on poor performance. I think this is really important.
Most important.
And just to start that discussion, we are currently dealing with a poor performance case, and we've had really good sort of documented evidence leading to we haven't yet terminated. It's still ongoing, and I was pretty impressed by how the managers went about defining performance, giving him, communicating with the employee, monitoring on a regular basis his progress, having a performance improvement plan in place, and again taking constant feedback from other managers and colleagues and all of that. I was really impressed by how they went about with it, and I thought I was pretty happy. But we are at a stage where the employee who is supposed to be terminated is claiming that he has been victimized because he had requested his manager to shift to another department in 1.5 years, and the manager said no. And since then, the manager has started this whole process of victimizing him and putting it all of that. So it was an eye opener how the employee, he's gone into referring that in 2015 my performance was satisfactory as told by my manager. Here is a copy of the email, and in some 2016 date I was also given recognition for my some work that he did on some project. He's gone on to small things in the last 2 years and picked up things which are in his favor, whereas everything else is not in his favor. He's remained silent. But I was surprised at how this case is evolving, where the employee is not really letting it go. So yes, as manager, it's good to recognize performance and all of that, but it is equally important to also document non-performance or employee issues or attitude problems or something like that. And what happens is that you like to say good things, but you don't like to say, at least in writing, the bad things that are happening. And that is where we as lawyers come back and force managers to say that this is not good enough because you should have written all of this, and now none of this is there. The manager said we had oral meetings with this employee and we told him about all these issues, but I said, where are the minutes of the meeting? Has he approved it? Did he accept it? How do you prove that these meetings happened and what was discussed? And there's nothing in place, right? So it just changes the whole dynamics, where he's referring to small petty things where he was given a good sort of recognition, or his performance was shown to be in good light, and it's very sort of sporadic, like one in 2015, one in 2016, and that kind of a thing. And now we are saying that how are we going about termination when he's raised all of these sort of things in his defense. And honestly, I think where the managers failed was to document all these meetings that happened about the performance concerns or something like that. I think that is where we felt that they could have done a better job. I mean, the process they followed is very nice, but this is where they failed, that this is all to be done before that process started, and they haven't done that.
On a practical level, I think this could actually be one of the key takeaways from today.
Absolutely.
To me, this is actually the most real and likely scenario that anyone in this room will face. That over the course of a period of years, that you have people in your team who perform very well, they get these awards, they make excess of their incentive for performance. But in the end, when you want to fire them, you have no documentation. And everyone says, well, as the manager, we remember this meeting on that date where we actually talked to him, but there's nothing on record.
Yeah, even if you don't have the meeting recorded, at least document after the meeting that we met and we discussed these points where you need to improve, and I hope you will take it seriously and all of that. At least have some couple of lines because he can always come back and say, no, this meeting never happened, or this meeting happened but none of this was discussed in the meeting, kind of a thing. So document, at least on this side, if not others, is really important from a sort of learning perspective. And not just your organization, it happens at our organizations where everyone is all keen to talk good things about what the good work people have done, but when it comes to talking negative, they just don't like to document. It's just something that even we as managers sort of face. And I think that's where you have to force yourself and say that at some point when you don't want this employee, all of this thing that you built over the last 2 years will really come into perspective, in terms of terminating his employment for poor performance.
So I think couple of points I want to add here, and which we have seen in a practical situation, all of this considered, is when you are managing a team, you want to keep your people motivated and all of that, right? So you're always balancing out that one day I may have to terminate and therefore I want to document, versus I have told them whatever the points and all of that, but still I want to keep them motivated. and therefore what steps to be taken, right? So there is a fine balance that one needs to always draw, because if you put too many negatives, obviously that person is not motivated, and he will start complaining, thinking that nobody's appreciating my work. That as an organization also is not something which is a healthy atmosphere to work in. So, but as Vikram said, if you are even alluding to something in the email to say that no, we discussed where improvement is required on 1 to 3 points, that is not something where the employee is likely to feel that I'm constantly being targeted or otherwise. It's a matter of statement, but at least that gives you that leeway at a later point in time to show that yes, in fact this was documented. And obviously the employee is not going to that time come and say that no, we never discussed discussed any of this. So it's a fine balance that one needs to draw when you're managers and you're dealing ultimately with human emotions. So one has to sort of be cognizant, but at the same time you are acting on behalf of an organization, and therefore what is good for the organization also has to be kept in mind. So it is your personal skill versus the of training people, keeping them motivated versus what is required for the organization. So sometimes you may have your personal belief to say that no, let's ignore some of the negatives and just keep, especially in the sales teams, right, where you have to sort of keep the targets going, keep them motivated. Some of these things may get overlooked.
Just one more question. Like, if people are doing medical appraisals and there's an appraisal report, in that if there are a manager is putting 3-4 good things and there are 3-4 area of improvements, will that document help later to so that these were the area of improvements?
Yeah, and another thing I have noticed is you have sometimes this rank based thing 1 to 5. Okay, and then you just simply put 3, 3, 3 and and be done with, so which is very standard that we have seen. So there is always a possibility of a column where you can add things, right? So it's important to take that extra effort to add a line or two as to where you will say good things, but where improvement is required, right? Because and somewhere you have to show that improvement, when you say poor performance, suppose for example I can't say somebody's handwriting is bad, I'm not able to read your notes, obviously not, but you have where it is actually impacting the outcome of the role that employee is playing, right? So how it is linked somewhere to that role is something, if you are able to document that helps, right? So this standard 3 thing is something which just doesn't help. But one can say I was an average performance, I don't have to be a superstar, but I was not a poor performance, I never got 1 or 2, right?
In fact, performance appraisals are so critical, and managers keep that section on drawbacks or areas of improvement so generic that we are like, well, on what is the basis now? Because if you've given him an average performance and you've spoken about all the good things and the negative feedback is very generic, it is not good enough. That process for termination for performance has to start well in advance. It could easily take 3 to 6 months, if not more. Okay, I mean, it depends on the seniority and level and the kind of work and all of that. And you can't be having an average performance in your performance appraisal and look to terminate him after 2 months for performance, right? That will just not work. Courts will never accept it. And today, performance appraisal reports are an integral part of any submission to the courts on poor performance. So again, a learning that don't let that section just be generic in nature or superfluous or blank or something like that. Go and put in. I mean, it's okay. At the end of the day, you are helping the employee to improve. Look at it from that perspective. You may be considered negative, but at the end of the day, you are helping him by telling him that these are the areas you have to improve. And don't just as managers you want to look nice to your team, but not always, right? I mean, somewhere it may not necessarily be nice if you are just going to let that point be ignored over time.
I think the other interesting thing that sometimes we have seen that it helps is there are times when there is some personal equation issue between you and your subordinates, right? Sometimes you get that feel that overall things are not all that good. But therefore what happens is, especially when you have to have these tough discussions, it is always important to get somebody else in the room, to also communicate things, what is good for the organization performance. So what happens is when it is not like a targeted kind of a thing that comes up, and even when giving evidence and all these things, these other things always help. So it is
As a
important
witness if nothing
as
else.
a witness if nothing else, exactly. So I think sometimes it is important to have that leveling to say that okay, this is going to be a tough kind of a discussion or whatever, if you get that feel. And sometimes it also is coupled with whistleblowing, for example, that because then that person has raised certain issue against you or whatever, and therefore whether the termination is happening because of that. So when some of these tricky issues are likely to arise, it is important to, if nobody else, your HR manager could be in the same room while you're having that discussion. So one has to be slightly careful on these situations where you know that that person behind your back may have complained against you or whatever, you get to hear things. So be careful when you are having one-on-one discussion, rather have 2-to-1 kind of a discussion without letting that person feel intimidated. Any questions on this? Because as Nicola said, this is the
to
most
me,
important
this is actually almost like an awareness training for everyone. And while a lot of the pointers that we have come up with are generally applicable across many countries, the fact why it's so important in India is exactly as Gauri said. I will tell you that our whistleblowing hotline, 90% are from India, right? I mean, you have here a culture where employees will allege that there's a problem which I reported, and then because of that now I'm being terminated. That there is very much a culture here. There is a culture here where employees, both in terms of the protection of the courts as well as the fact that employees here will challenge a termination decision, I think more than in some other countries where they accept it, contractually you say you're able to terminate, all right, fine, I'll go. So I think with the reality of the practical situation here, these are pointers that our managers here really have to take into account.
I'll just give you another example of a situation that happened a few years ago and very interesting, where the employer decided to terminate this person for whatever reasons. It didn't want that employee, and it went on to a meeting, just how we do it in India, right? You go into the meeting and you get them to resign. So they went into a meeting on Friday. The employee said, give me some time. So the employer said, okay, the manager said, okay, we'll meet on Monday again and let me know your decision. None of this was documented, unfortunately. It was all oral and all of that. Over the weekend, the employee sends an email to the global team that he's being harassed because of his race and that he's from some South India or something happened, or some particular community. That went to the US. The whole matter got turned in a very different way than it was supposed to be. A simple resignation turned out to be now that the employer is now defending that why we are not discriminating you, kind of a thing, like. So again, it was also a learning for us that don't start this on a Friday. You do it on a Monday or Tuesday. Don't give him so much time, kind of a thing, because over the weekend he'll go and he'll meet his uncle who's a lawyer and he'll complicate the matter and all of that kind of a thing. So that was one learning. Second was that if you've gone into the meeting and you've given him time, at least send a mail thereafter that we spoke and we met and there were these concerns and we look forward to your decision in terms of within the next 24 hours or something like that, so that it doesn't go. I mean, I was really impressed with how that employee came up, and it's been a learning for us also. So just as a sort of, I thought it would be a good example to share how creative employees are in this country.
And the other thing also, sometimes I think once we get into the misconduct and all those discussions, some of the examples we'll want to share. I'm cognizant that it's already 3:30, so I think we also need to move.
What time we finish?
I think some of them have
and I think some of them have flights.
So we just have to be careful here.
So we should have your chartered flights on.
Who has a hard stop at 4? How many have a hard stop at 4 because of flights they need to catch? So we know whether we've got some time to go.
4:30. I'm at flight at 6 o'clock.
So can we go to 4:30?
Oh, enough time. We can leave by 6:30.
No, okay, fine. I just want to know. So maybe 4:15.
Yeah.
And so the other thing I want to say is, and I think those of you who have actually been involved know, when you have someone in your team that you've tried to terminate who's challenging it, and this is connected with the whistleblowing. I can tell you, when you're the manager who's involved, the amount of your management time it sucks up is not fun, because you have a business to manage. All of you actually have a business to manage, and you're accountable for delivering your number for that week, for that month, for that quarter. And the amount of time you're going to spend talking to me or to HR or to lawyers or to your compliance team is really not fun for any of you. So that's really,
As managers,
really
you
when it
don't.
gets painful.
As managers, you don't get paid for overtime. So.
Yeah. Some of you have learned from painful experience. Yeah.
Completely.
Yeah, you should be teaching us.
One very quickly, given the importance of this, is it possible to share some case examples and some do's and don'ts?
Yeah, sure.
Yeah, exactly.
Another issue is that people who are managing people, most of us know what is to be done, but we don't do it. Like, I don't think any manager out here does not know how a documentation needs to be done for the employees. But number one, I think, especially in our setting, the cases of terminations are it's not so often.
Correct.
And we think that, okay, somehow it will go off. Yeah. It's once in a while that it happens. But I would say, like, these are basics. We all know that this is what has to be done. This is how the bail should be.
No, it's
but
both.
we just don't do it.
I think it's both, Ajay.
Even when, even when we
You
write
may
out,
know, but I think there are people who don't know. That's why.
like I'm saying, people who are managing people for last 3, 4, 5 years. For example, I would say, like, even when they are writing a mail for some kind of improvement, they will try to cover it up as saying that this is not expected from someone who has been performing brilliantly over a period. The whole thing is gone. The moment you write that one sentence, but it's so common to see when you write it is not expected from a person.
I think what we are trying to say here, how legally it is going to impact you in the future, and that's why you're re-emphasizing what you already know in terms of the impact that is going to have on the consequences that later on what we have to deal with basically.
And of every 3 employees that you may terminate, maybe only one will become really difficult.
Exactly.
But as some of you
But
know,
you'll always have those 1 or 2 employees in every
one
organization.
difficult one is enough to scar you for a long time. Because it really, really takes up all your time, and it's very time consuming and very troublesome.
Yeah, and I mean, to your question, you can have generic do's and don'ts, but honestly, it is so situation specific that you can't just apply those principles. But just another point of recommendation is, and just leading to that point, is a lot of time managers try to deal with the situation on their own. And recommendation is to try and involve HR or legal as early as possible into the discussions, rather than trying to say that yes, I know it all and therefore I will manage it my way and all of that. Try and get somebody else's views, especially HR or legal, or someone else who may be able to look at it from a different perspective, in terms of how to go about it. So just as a piece of recommendation, yes, you can handle it, but if needed, or at least if you can bring in another person who has a different skill set into the play earlier, could help.
Yeah, because if you go ahead and say, for example, issue the termination letter and you don't have any documentation and proof to back it, then whatever you create after that, the courts are not going to take it, and obviously they're going to understand that we try to create a case out of it after the termination already happened.
So one of the learnings as well that I think is key is the distinction between termination, which we will get into, but between termination for misconduct and termination for reasonable cause. Because when it's for misconduct, the need to have taken procedural steps beforehand is really going to be critical. And so that's, I think, one of the things which we'll get into in the next couple of slides. But that is a key learning as well for us.
Yeah, so quickly going through this, so basically so when we talk of simpliciter termination, a lot of factors are involved, like the location. That's why we were trying to assess where all are we located and where all we have establishments. Then we have so we already are an establishment, so the second point becomes redundant. The third one is with respect to the roles and responsibilities. So as we said, the more defined it is, the more it is better for us to understand whether workman or not workman, what all laws will apply and all. And lastly, the duration of employment would determine basically from a finance point of view, what all would be the F&F and other things at the time of termination. So all of those things are governed through these factors. The important bit is with respect to documentation. Now there are, and we would have names for each of the document, but at the end of the day, these are not mandatory documents, but obviously, as in under law, not mandatory, but obviously from a documentation perspective, most important. Like a show cause notice would be something that you would want to give to an employee when you see a case where the say for example the performance is not going as per expectations, or there is some loss of confidence or something, you want to basically tell the employee that okay, this is not going fine, why don't you tell us what is your reason behind it, why these things are not going fine, and you have this much of time to explain it to us. That would be like a show cause notice. A termination notice obviously would come at a stage when you've already had documentational proof you are ready to terminate the person. You will issue the termination notice along with a reason and notice. That's what the law requires you to provide for within the notice, within the termination notice itself. And that's where we come into picture. We would basically guide you through the process in terms of what kind of documentation would be required at the time of termination. And the last one is separation and release, which would be like and it's more a document that is more so a document that is used in the US and the UK. India is now starting to use it. The courts haven't come back with any judgments or any, there are no precedents per se with respect to this, but in terms of the enforcement of this document. But basically this is something with respect to at the time of termination, you would want the employee to sign saying that you hereby release us from these claims and liabilities as such at the time of termination. Now, financial obligations.
We'll skip that financial obligations because that's separate. You can have the slides on the financial obligations. So let's not get into that.
Yeah, so
that's not in dispute.
That's more like
that's not in this.
Yeah,
that's not contentious. That's something that we have to do with.
Yeah.
So the important bit. Now we come to the third mode of separation, which is misconduct. Now we have to really differentiate between termination for misconduct and a termination for a reason per se. So as I listed out previously, there are a couple of reasons that the courts have held, like poor performance and other things. Those should be segregated from misconduct. Now misconduct, there are a few of these examples which we've listed out here. Usually you would have this in your employee handbook, or if you have standing orders per se or something, there you would have listed.
I don't know, where do you have your...
It's in the employment contract itself.
Contract itself.
Because we don't have an employee handbook, right?
The reason for termination is mentioned.
So all this goes into your contract.
Yes, yeah. We don't have a handbook.
No, we don't have one for India.
Do you have a code of conduct for India?
Yeah. Not for India, it's the same.
It's a general code of conduct. See, typically you need this listed somewhere if you want to terminate for misconduct. You know, that's what.
The point
in the contract.
I mean, these are just examples.
So
we've had we have a list.
Reason for termination. One of the reasons is misconduct. It's in the employment.
No, but all of this. Exactly. So I think that's another. Somewhere we will have to create.
So if you see, remember we had looked at their contract, and that the identification was not there of misconduct.
Yeah.
Yeah. So it would say that. It would say that it can be.
Honestly, that's not good enough. We can try and go under misconduct, but it's not foolproof. So it's not something.
I think this is something that you need to bear in mind, and I think we might be able to leverage the integration because I suspect with the size of their organization that they will have handbooks.
Yeah.
Right. So, but it is something to bear in mind, and assuming that's not going to take place in short term, to bear in mind whether or not the need for a handbook for the interim period is to be considered. Can you just think about that? I think the answer is that we probably will leverage the other one, which I'm sure exists.
Yeah, I think so.
Yeah, but can you think about that issue?
In fact, in some Indian companies like the banking, insurance, and those kind of Indian companies, like who've been doing it since years, the examples or the acts constituting misconduct could easily go into 2 to 3 pages. They're that detailed because we don't have actual, right? So you have to put it out that if any of these things happen, it is going to be considered as misconduct, and then we will follow the process and terminate your employment. So they go into a real significant amount of examples. And again, not that these are all well defined, but they're still put into some document to be able to refer to.
Yeah, because the issue is that the law does not define misconduct. So it's now up to the companies to almost contractually define what they will regard as misconduct.
Yes.
Yeah, and what the courts will appreciate is if you have, so obviously you would say that the person was terminated for misconduct and we followed the procedure and other things. What the courts will appreciate is whether you listed them down, whether the employees were actually aware whether this particular, because there may be finer nuances with respect to say an ethical issue or a thing which was actually misconduct. So if you've listed that out, that always provides that kind of
black and white to determine.
What is the definition of damage?
Damage is common.
Laptop gold. Does it mean that any data or electronic
That's correct.
Yeah. So that is a separate section of IT system, whatever damage or theft of confidential or proprietary information or deletion of sensitive data or something like that.
Because that's something we are noticing more and
We
more.
go into those details into the acts constituting misconduct. This is, I mean, the way I would read it, this would be like a physical damage to your property kind of thing. So
Then that happens mostly after the termination of case.
Sorry, what?
After the
revision of the
property, we see
Yeah.
that the data is gone.
So
It's
this
mostly
is
like
something
after termination.
which is very common right now. We are dealing with a situation where there is a dispute on which is the right distribution contract that was signed, because there is some proceeding that we are engaging. The reason I want to spend some time here is because there are employees who will be handling your contractual relationships on a regular basis, and some contracts may have been entered into or some arrangements may have been entered into in not up to the mark, the method of doing things or documentation or whatever the arrangements are not as per the company policy. So right now we are facing a situation where it seems there are two employees who have left, and they have sort of exchanged certain information which we got to know once the arbitration started, where the other side showed us that this is what they had promised us. When we tried to search that, as you rightly pointed out, they had completely deleted their email systems. Right? So when employee resigns or where there is any discussion about resignation and all that, the IT department has to be extremely cognizant on what is being happening on the company property in terms of deletion or otherwise. And that time also an alert that you're supposed to, because many of the companies have this document retention policy or email retention policy. So awareness of that is extremely important. So right now we are in a situation where these two employees have completely deleted their data. We have no wherewithal to figure out what other communication that they may have promised. And you have a concept of what is called as doctrine of indoor management, where the other party is not supposed to know whether that person was authorized or not. So the promises are being made on behalf of the company at certain levels. We also had another situation where we are actually dealing with right now. We are getting into a lot of forensics and all that, where at a very senior level person in a very important company within India, he resigned, and separation and all of that. And there are certain regulatory audits and all that, and he has completely deleted that data from the laptop. So that's a completely independent issue, but it's a very important issue we are noticing right now, because now everything is on emails, SMSs, WhatsApp and all that, and it's getting extremely difficult to track all this, so it's important for IT department to sort of track the deletions and all that on a regular basis.
And a separate point that's done is second point on sexual harassment. Again, we have a new law on sexual harassment, and obviously there are processes under that law and how to go about with it, and having a committee in place and all. Not part of this session, but again that's a critical area from an organization standpoint.
Yeah, so coming back to this particular mode of termination now, why is it important? Because the fact is that if you are terminating for misconduct, you need to prove that within a disciplinary inquiry or a domestic inquiry that has its own procedure which is to be followed. Now, So I'll skip the documentation bit, but before that I'll come to the procedure now. Uh, when you are terminating for misconduct, you need to have an entire inquiry process set up with respect to, say, for example, you'll have to have an inquiry officer who will be before whom the employee is required to depose and basically present his or her case with respect to whatever allegations have been made against him by the employer in terms of whatever misconduct there was, say, for example, damage to company property or any other kind of misconduct like financial impropriety or something. In this inquiry procedure, that entire misconduct has to be proven, and the report will be issued by the inquiry officer. And finally, based on that report, we will take a decision whether the entire thing requires termination of employment, which will be the last stage. That the misconduct was so grave that it required termination of employment, and that is what the courts will want to see per se, because the courts may also come back and say that okay, the misconduct was not grave enough, because if you see here, what is required to be noted is that the quantum of punishment that is to be given to the employee has to be proportionate to the kind of act that he would have done. That's what the courts will go into. Now, the issue here is when we have a reasonable cause to terminate, and then there is a blurred line between reasonable cause and, say, for example, it also falls within a misconduct. So how do you actually document it? Because at the end of the day, the employee may use it, as I would like to come to the previous point that I was raising. The employee would want to raise it, saying that it was a termination for misconduct as compared to reasonable cause, and therefore the entire process should have been followed. So that's where the importance of documentation would come through, in terms of whether it was for non-performance or whether it was for misconduct per se. Now, these are actually the principles of natural justice that you would require to follow, which are more important for the inquiry officer per se who will be appointed with respect to the domestic.
We have had very interesting situations as to, if you remember a few years back, we had a situation where we had to terminate the employment very urgently and had to give this notice of, show cause notice, hold the hearing. So all of this process, the way it is conducted, ultimately the courts will look at it. Like, for example, if you are giving the notice, say a show cause notice at say 6 o'clock in the evening, and hold the inquiry or require the employee to respond no later than 2 p.m. tomorrow. So these sort of situations, one has to be careful on the whether the courts will look at each step, whether it has sort of complied with the principles of natural justice. When we say principles of natural justice, on the earlier slide we have laid down. So, for example, suppose your notice says you have been, it's a misconduct, that's it. That doesn't help. You have to give the ingredients of misconduct, right? So, all these details have to be articulated. So, there are at each level what needs to be done. Of course, you will not do it yourself. You will have your HR department or legal department to help you. But the importance is to be at that stage be able to identify what really is a misconduct for which you are terminating. Are you able to prove that? You need to go back, collect evidence, and be satisfied that yes, this is something I can allege. Because if you are alleged for sake of alleging 5 points, and you are not able to prove 4 out of those 5 points, it doesn't really look good in front of the court. So, it could be just 1 point, but with proper evidence, it's sufficient, right? So, don't necessarily have to go overboard on what you are alleging as well.
Yeah, the important bit here is obviously if it's an outright misconduct, there is no doubt in that, and you can obviously take a call on that. But there are situations where there is a thin line, a blurred line between misconduct or maybe reasonable cause and all. In that case, when you are in doubt, maybe you should approach your HR or maybe legal and all in order to figure out how to exactly structure that communication that will go out to the employee, because that is the most important. Today, if you write that you are being terminated for poor performance and you are also being terminated because there was financial impropriety, then in that case we are in a fix how to go about it, whether to go about with the domestic inquiry process or whether to just terminate because of non-performance. So we'll have to identify what is more important, what has more evidence backing it, and accordingly we can give that kind of reasoning for termination. So this is the entire set of documentation and the process that is usually required, and as Gauri suggested, the process is important because the courts have went on to the extent of saying that this particular step was not followed and therefore the inquiry process in itself was vitiated and the termination is illegal. So that's the importance of it. And the last point, as I mentioned again, that the punishment should be proportionate to the gravity of the act or misconduct. Yeah, so coming to employee recourse, now when a matter goes to litigation, these are the kind of remedies that the courts will give to an employee if the employee is successful in litigating and a favorable order is passed in favor of the employee. Now it will be reinstatement with back wages, which is from the time that the person was terminated till the time that the judgment or order came through. And in some cases,
so basically put him back where he belongs, right? In case of a illegal or unlawful termination, courts will basically say the employee must be reinstated. They won't really go into calculating damages or compensation unless the company is closing down. That's a different thing. But other than that, in a majority of the cases, the courts have come back and said that the termination is illegal. Either process was not followed or the reasons are not good enough or there's no justification, and accordingly the employee has to be reinstated. So he's going to be coming back to office and working under you, and you'll have to figure out how to deal with it, right? That's the other challenge.
So
That's
only workman goes in the labor court, or in because the definition you gave for the workman, it was too broad. So which court normally?
So see, the court system is labor court, industrial tribunal, high court. Then there are labor commissioners. So depending on which law and which courts are provided under that law. So when it's a dispute in relation to a workman, it will go to a labor court. But when it's in dispute relation to an employee who is not a workman but covered under the Shops and Establishments Act, then the labor commissioner has jurisdiction. And then eventually it will go to the high court. So it depends on what courts under which laws have that jurisdiction, and that could change depending on where that employee is located.
And again, every employee would typically try to categorize himself as workman, so he would usually go to a labor court.
Yeah, so we have a situation in Bangalore, I don't think any of, they don't have a premise there, right? But there is a very peculiar clause which says that if, upon termination or otherwise, if it is found, not appropriately done, if the employer doesn't want to, doesn't agree or not willing to reinstate the employee, then there would be damages calculated, and there is of 11 months wages or something like that.
1 month per year.
1 month per year. In that case, it was 11 years. So, so that kind of a calculation, right? So this employee is, he went right to the Supreme Court to challenge various things and all that. But now what he's saying is that the labor commissioner did not make a noting that the employer is not willing to reinstate, and therefore the original order is bad, right? So some of these things which are very, very procedural, one has to be aware that sometimes when you do these documentation, it's important to say that we are not willing to reinstate you. So that communication also is very important, because that has an impact under certain laws in a certain way. So what we are trying to say as that every communication that you take in these situations, there has to be some legal reason why why you're doing certain things in a certain way. So it is important to know that at least issue identification we are doing today, so that something you have to say or write or whatever, it's better to find out what is the category, which law, which state, and accordingly do the communication, right? So yeah.
In fact, the other issue is the practical reality of dealing with litigation, right? You have an employee, you have your headquarters in Hyderabad, but the employee is in Jaipur, right? And you don't have an office there, but your employment contract said that you have to work from Jaipur, whatever sales function or something like that. So you already allowed him in a way to go to a labor court in Jaipur if he is not happy with the termination, right? So again, you made it very clear that because the employment or the cause of action, as we would call it in legal sense, is in Jaipur, he will have, the Jaipur courts will have jurisdiction over that particular employee. So you as the manager will have to keep going and depose in front of
But
some.
even if the contract mentions that all proceedings in India will be in jurisdiction of Hyderabad.
That's it has. What does it have?
So if you have that particular line, we include that in all our vendor contracts and also in all
Jurisdiction
in Hyderabad.
But I
In
don't.
that case also.
But that's not enough because here
Yeah.
the cause of action could have arisen in Jaipur because you allowed him to remain in employment in Jaipur. So
the labor
courts,
law will
courts
say-
will in Jaipur will accept it.
See, because ultimately the labor laws are employee friendly. Right? So if they believe that it's going to be a hassle for the employee to go all the way to Hyderabad and litigate his issue where actually he is actually working in a different state and that state law should apply, if they take that view, then they can entertain that matter.
So in some of these cases, how we structure the document at least on paper is to say that you will have to report to the Hyderabad head office from time to time. Although because of the nature of your work, you can at times work from remote location or something like that. So we put it generic, but we make it clear and we won't add Jaipur in this kind of a case while drafting, but make it generic to say that you can work remotely depending on the nature.
How much the court will accept such kind of sentences at a later stage when the person is based in Jaipur
That's
for
true.
5 years?
So that exposure always you're right. And also sometimes there could be communication even from the manager that the documents say whatever, and then there could be a communication. Yes, you can continue to work from there or whatever. So that kind of overrides, right?
No, correct. So that you're correct, and that is the fundamental conflict of the situation that we face. There's always the reality.
Yeah.
But then, insofar as and documentation in and of itself can never completely save you, but especially in the employment area, things are very much the weight of evidence and how much it adds up on one side or the other, and there's so many different factors. So that having your contract say one thing is just one of multiple factors that may help a company's argument on one side. That's all. But it will not determine it in and of itself. It's just one of multiple factors.
So this letter says, the appointment letter that we have, it says that laws in India and the exclusive jurisdiction of competent court in Hyderabad.
Yeah, we have seen that. I remember seeing this, but again, the same issue arises because ultimately, one can argue. Okay, it's a very technical legal argument. What you are agreeing to is in relation to the contractual dispute, correct? For which you have agreed Hyderabad. But if there is a protection under law that is being provided to you, which is outside the contract, then it could be argued that even the protection provided is under the Industrial Disputes Act, and therefore it doesn't matter you're not raising a contractual claim, you're raising a legal claim under the Industrial Disputes Act, and wherever I'm located I could go there because the cause of action has arisen. So that's where I'm saying it's a tricky one in fact.
There's no clear position. And typically in this case, the employee will go to a labor authority in Jaipur. We will go and say that Jaipur court doesn't have authority, it has to come to Hyderabad, and then it's whether for the court to accept that argument or not.
This is just a small list of unfair labor practices, as Vikram had initially pointed out that there is a specific law in Maharashtra which talks about unfair labor practices, as well as
on the part of the employer.
Yeah, this is on the part of the employer. There are separate lists which would talk about unfair labor practices on the part of the employee as well, which are listed in the law. And then there is a separate list under the Industrial Disputes Act as well, which talks about unfair labor practices, just for guidance purposes. And last is some of the best practices that we can discuss. One is priority should be with respect to resignation as compared to any termination of employment. And this is because of the fact that, as in for both the sides, as in for the employee as well as for the employer, India doesn't view termination the same way as US does. It has a stigma attached to it, or a taboo attached to it still. So usually in certain cases you would want the employee to resign and you would incentivize the person to resign in terms of payment in lieu, payment in lieu of some months of salary or something, so that the employee resigns. Obviously, there is that impending risk of the employee saying that he or she was forced to resign, so that still remains. Second is,
I mean, I think on this point, basically keep your ego aside and just see what is practical and what is best for the company at the end of the day. Whatever may be the reasons, but if you are getting him to leave, and you don't really have to be so sort of theoretical that I want to teach him a lesson, and I will sort of ensure that his career is ruined and all of that. You really don't need to get into all of that. In fact, we were just talking with Nicola before the session here that in a situation where an employee leaves and has been gainfully employed elsewhere, the litigation risk is really very low, kind of a thing. So you really want him to go away and be employed somewhere, because if he is free, basically an idle mind is a devil's workshop. So he'll do anything and everything possible. He'll send you legal notices, he'll write to your management, he will copy the government of India, different departments on that email, and he will do the most random things that you can not even have thought of. And that is where you're like better off, keep that sort of ego aside. You don't have to teach him a lesson. As long as you got him out of the company, it's good enough. You achieved what you wanted to. Let him figure out what he wants to do in life.
yeah, and just to add to that, a couple of employers as a best practice also have these outplacement services, where they would ensure that the person gets a job somewhere else. Because those are the kind of incentives as well that you would extend to the employee, that okay, you are not fit for maybe this organization, maybe this is not working out for you, so why don't we look out for something for you, so that he is gainfully employed and he doesn't get into litigation eventually and stuff. Then you have so the second point is, I think, more relevant for people who document full and final settlement and other things, that the kind of terminology that you use there, and even in other documentation or other emails, you shouldn't be using, when it's a resignation scenario, you shouldn't be using terms like termination your employment is, because usually we tend to use a lot of loose language in terms of your employment has been terminated since this date or something. So let's avoid that, because courts usually get into each and every word when they get into reading the evidence that you produce before it. So retrenchment, compensation, and notice period especially is something that you would usually find in termination cases as compared to resignation.
One classic mistake companies make in a resignation is that they say we will pay you for notice. Now, if the employee resigned, he's the one who has to provide the 2 months notice. Why should the company be paying for a notice that the employee has to provide? But it's a classic mistake that they end up making. In their FNF, they say we are paying you for notice of 2 months when he has resigned. That in itself is a giveaway to say that if the employer paid for notice, did it mean that the employee was actually terminated? So again, don't call it a notice period payment if the employee has resigned.
What should be the
Ex gratia, goodwill payouts, but not notice period. No, it's not you. Everybody else does it. I mean,
it's common
parlance. Why are you paying
but,
for notice? You pay him. It's okay to pay him that amount, but pay him in some other heading. Don't call it a notice pay when he was, in fact, required to give you notice to resign.
Can you use the word compensation like that?
Compensation is too generic. I mean, compensation will include your salary
or whatever
and benefit.
So, in case of an employee resigns with a 2 months notice period, and ideally, we just want to get rid of him somehow. So he resigned, and he decided to serve the notice period of 2 months. But company doesn't want him to be on the roll for 2 months. So we tell him that okay, you're relieved from tomorrow, but then we pay that 2 months salary, like that notice period. Anyway, there is this eligibility to get that.
In fact, I would say that we don't need to pay that 2 months salary. What we're doing legally is actually you're waiving his notice period.
Exactly.
So the employee has an obligation to provide us with 2 months notice, and to work during that 2 months. But we are waiving that requirement and saying, no, we don't require you to work during that 2 months. So we are waiving that requirement.
I
do we
think-
have a provision in our case
No,
that
I
employee
just-
can always go back to the court and
Yeah,
say
so
that?
I think the issue that could be that the employee will say that I want to serve my notice period because he doesn't have another job, right?
Right.
So he needs to get paid, and that's the reason you're doing this. So another approach could be to say that your your accepted resignation, and we have used in some situations. I'm slightly digressing here, but garden leave kind of a concept that okay, 2 months you will not work, your employment continues, but you will not come to office.
But he still gets paid.
But he gets paid. So ultimately, what you don't want is to him to come to office, right? So that is achieved by this garden leave, and at the same time he gets paid. And if in the meantime you say that if he gets an employment in the meantime within those 2 months, then that parties can mutually agree and reduce that period. I don't know, Vikram, you have any thoughts on that?
So in case of this garden leave, the employee still remain a part of the
Exactly,
organization.
that's right.
He's on the
Serves
roll
out
of
the
company,
notice
he can
But
still
in
go out to the
but in
market
case
and
of
make-
resignation, whether it works or not is something we need to think through.
So in a situation where an employee has resigned and is willing to serve the 2 months notice, you as an employer cannot not pay salary for that period. Because if you stop paying salary,
No.
no, I'm just giving an example to say that I'm treating tomorrow as your last date of employment and I won't pay you. It's
No, we pay you for that 2 months.
no, forget that. If the employee says I hereby resign and I'm willing to complete my notice period and after 2 months will be my last date of employment, you as an employer can't be saying that okay, tomorrow is your last date of employment, because it will construe as if it's a termination of employment and not a
Exactly.
Now, whether you want him to sit at home or come to office is fine, but at the end of the day, he will be entitled to
For that
salary, and tomorrow can be the last date of employment. For your records, it will be 2 months later. But if the employee and you can discuss and mutually agree to an earlier date of relieving and he's fine, that's fine.
Saving
And in that case, you can agree on an ex gratia as you were saying, but
but you
don't
can-
say it as a notice period.
But you can still agree on the conditions of that 2 months, so you can
Yes.
you can give him cut his access to
Absolutely.
network.
Absolutely.
So you're entitled to do that, Resya.
Yeah,
You can
absolutely.
cut access to network. You can say you don't have to do not come to the office.
Absolutely.
Yes, that
In
you're
fact,
allowed
yeah.
to do.
So that's what you want to
But-
do.
and-
That you.
But technically he is on the payroll.
Correct.
Technically,
Yeah, correct.
he is technically an employee, and that is relevant as far as benefits like medical benefits and insurance go,
Right.
for
Correct.
instance, because you will have to provide that for that 2 month period.
Nicholas, I have a query. When you say cut access to network, is that allowable under the
Allowed for
Yeah.
under
Yeah, you
whatever
can. You can
protocol?
cut
Yeah,
access.
very much. Feel free.
And that's the.
Just ensure that it's well documented that you no longer will have access to the systems or computers, or please hand over the laptop or phones back and all of that, and you will remain on garden leave. Please have it well documented before you cut.
Correct. So I would say in every case, these special stipulations, which may be employee by employee specific, right, will have to be documented in each case. Because with some employees, we are sensitive, and for particular reasons, we don't want them to have access. Because we suspect that during that 2 month period, they're going to be downloading stuff, passing information, for instance.
Correct.
But then we also have employees that were perfectly happy for them to continue working for the 2 months. So
Correct.
every situation is different. But where we have a set of special stipulations, this has to be documented.
But that's a very good point, and that's something which we encounter nowadays quite often. And where the employees, like if we are if you are resigning, he is at such a position, has access to so much of your data, distribution list, and all of that, and you don't want that thing to continue for the next 2 months. Simply you can stop.
In fact, there is another reason to keep him on rolls for that 2 months, because he cannot join a competitor for that period.
Yeah.
So in 2 months, he continues to be on rolls. He doesn't have access to your systems. He gets salary, and he cannot join a competitor because legally he is still employed with you.
And waters his plants in his garden.
Sorry?
And waters his plants in his garden. That's the garden leave, right? So.
Yeah.
Because he has all the time. So that's the entire purpose, I think. Because in India, just to add, in India you don't have, you cannot enforce a post-termination non-compete obligation. So that makes it.
Yeah, let's not get into that.
Let's not get into that.
So moving on, I think we already covered this earlier. I think I just wanted to make one other point. On the other side, where the employee is required to serve the notice period, but in a lot of cases, what you see is that the employee doesn't serve the notice period and runs away the very next day. And the employee was supposed to serve that notice period. It is not advisable to deduct that amount from his salary. That is what usually most of the employers do.
But really, you have no recourse as an employer then, practically speaking.
Yeah,
correct?
so legally speaking, it is not advisable, because legally speaking, then you'll have to approach the courts for basically asking for those as damages.
I understand, but practically speaking, so you're saying that companies really have to write off that 2 months.
Yeah,
Really,
that's correct.
practically speaking, in India, there's not a lot you can do. Is that what you're saying?
There's nothing you can do, not a lot. I would say nothing you can do.
Well, nice to
Because
know.
you can't.
Nice to know.
Yeah, because there's
These
a
are
law.
personal contracts, so you can't get them to be specifically performed. So
You can still charge him back like under different heading.
you can sue for damages for breaching the notice period record. That's it.
You cannot deduct it from the
So I'll not
salary.
deduct from this base salary. That will be like no, but then there is a deduction column I can show that.
No, that's
No.
So you
So
cannot deduct
practically
it.
speaking, let me ask you this question. I understand the advice you're giving, but practically speaking, as a company, if we were to deduct it from amounts that are owing to the employee, what is the employee's recourse and what is the downside for us? They make an application to court, they say this was an unjustified deduction, but what is-
Unauthorized.
an unauthorized deduction. What's the downside for the company? Because I would still rather control that, to be honest. Unless there's a severe downside, it's something I would consider.
Well, it all depends on how likely the employee is going to press for that payment.
So if they are going to press, even if they are going to press, if the worst comes to the worst of the company, I just pay it, right? It was what was due to him anyway.
Yeah, you'll pay it, but you'll have to go through that process, right? So you don't want to be seen as if you're violating a label or provision.
Alright.
We'll get into
Well,
it.
the point.
Discuss that when it comes up.
No, but see, the practical way to handle this is to tell the employee that I give you a check and you give me a check. You give a check of the amount that you are supposed to pay for not serving the notice period, and I give you a check of the FNF.
Okay.
Instead of you deducting, you are doing a
Did
give and take.
Did you know that? This is, I think, most critical for you. I think you just missed that last point. Can you just say that again, Patricia? The way to deal with it.
So instead of deducting from whatever salary is due FNF till whatever his last day,
Exchange checks, right?
it's safer.
That couple times.
Because then you're not deducting, and there are laws prohibiting you from deducting beyond certain limits and for certain purposes.
If they have some due expenses,
That's
can
correct.
you put that?
Yeah. And expenses,
Like T&E.
Documented expenses.
T&E.
I think that there is a list which allows.
if he has expenses to
deductions.
claim, then he will claim from us, right?
Yeah.
No, so you deduct it against that.
Against that.
It's not
Yeah, it is
salary.
not the salary.
Yeah, I think if it's outside the purview of wages, you have greater flexibility.
Yeah, that's
Okay,
true.
that's good. Sorry, I'm just mindful of time, so
I think
this is
that's
just a housekeeping. For those, I think like Sumit, who have, if you have to leave, then let us know. If there's anyone who really has to leave, let us know. Otherwise, we'll
Yeah,
we'll
done.
go on
Yeah,
for
actually,
another
this was
15
the
minutes.
last slide.
They're done.
We're done.
Okay.
Just one more question. Like, suppose there is a pending inquiry which is going on because of a misconduct, and during that time, the person resigns. Should we conclude that inquiry?
Please go ahead and accept the resignation, and that's it.
Immediately.
Because as it is after inquiry, you are going to terminate. Why go through
The
that?
whole thing was that again, if he comes back and say I have been forced to
Yeah,
resign
well,
and
so
stuff like that.
I mean, how I would approach the situation is in the resignation acceptance mail. I'll put a line to say that as you are aware, there was an investigation and you were subjected to an inquiry, and because you resigned, we have decided not to. I mean, something I would make a
In
reference
good faith, not continue that. Something like that.
because there's no reason to do so.
What if in case there is an employee, there's a bond in place between an employee and the company, which is for probably for a higher education program or something.
Training bond.
Education support.
A
You want to do
person
an
wants to
MBA
do
and
an
the company
MBA,
sponsor.
and we have
Higher
sponsored that.
education bond.
And we have
Okay.
a bond that after this year you have to service for 3 years, and he leaves.
2 years. 2 years after the completion of the program.
Have you all signed anyone?
No, there are people who have signed. So what if that person leaves and...
No, but in this room, if people have signed, we'd rather not discuss.
Those who sign should be keeping their ears closed.
Those who sign, please step out.
So
Yeah,
see, you can't
Let's deal with that.
force
Yeah.
and
let's do it
Let's deal with that
offline. Okay.
offline.
So that's a step. I mean, there are several other things which we've not covered in this. Our focus was only on employment termination based on
But I
Nicola's
guess my
instructions.
question for you guys is, genuinely, if you found this useful, we're always happy to schedule more sessions, different sessions, submit your list of questions, all the questions you ever wanted to know about hiring third-party consultants or whatever it is, and we're happy to do it. It doesn't have to be, we thought, this is also an experiment for us. We thought there was value in having a face-to-face where we can have these, discussions. We can do it by WebEx in future, whatever suits you guys, if this was useful to you. And if you have specific things that you want, feel free to let us know. We can do follow-up sessions on other related topics.
We're happy to travel to Singapore also. No problem.
So the reason why we did it in Mumbai is so that our lawyers are here, so they don't have to travel.
No, but I think
I think we need to go more into the documentation process. More do's, don'ts, what are the good practices in documentation and stuff like that. Because that's the key
No, absolutely. And I think there are 2-3 buckets which I see now. One is the third-party contractor hiring overall as a question, right, on various functions and all that.
Yeah.
So probably that's a separate discussion to sort of examine the current situation. The second is, after today's discussion, you can sort of go back, think through, and what are the various situations from a documentation perspective. Then we can share with you some of the best kind of mails or some or whatever, or get into some specific case studies. I mean, today we have tried to give you as many case studies as we could, in terms of our experience sharing. But basis this now, because now how the organization works, you can now tell us that okay, these are the situations. In this situation, what is the nature of email or a document that should be sent? Then we can sort of start that dialogue as well. So. And that can be probably even structured in terms of through your HR and legal. We don't necessarily have to meet. We can exchange notes and things like that also, right? So, and of course we'll have to revisit some of your documents basis today's discussion and all. That's a separate exercise with legal and HR.
The consultant thing which we have, that can be individualized to each of the department, because each of us have different needs. And
if you have a list of questions that you want to set up, I'm happy to set it up. We can do WebEx calls for those who are interested in that. Maybe you can coordinate it through Fresia with your list of questions that are relevant for you, but then maybe applicable to a few of the other shared service functions as well.
It's on the assumption that we can answer those questions. I have no clue what those questions are and how.
From a legal perspective.
There's some wedge roll if you can just help us out. One for the road, that is. And the other area that we've been spending some time with clients is on dealing with sexual harassment allegations. That's one area on top of the agenda for several companies, and it's a highly sensitive topic in India at this moment, kind of a thing. So.
Thanks, everyone. Thanks, Gauri. Bye-bye.
Thank you. So for that also the training requirements are there as per the law. So that is another set of training under the law that is required for the managers and overall organization as such. Under the law itself, the training is required. So it's another area you may consider as well.
So my request to all of you is going to be, train people under you who are managing a team, so that they are aware of the process and documentation that to be kept in mind. Are we getting a copy of this recorded session as well?
Yes.
Okay, so we can send it across to them for a refresher.
And I think it should be also included for all the
induction
program for the managers, like when they come on board.
So let's think that through, because
small session, not to that great extent, at least the best practices has to be shared.
I think there's certainly some points that I would say that every manager should bear in mind. But there's also a balance to how many in the organization you want to train.
No,
That's why it
actually,
was.
many of these points can be covered if we have a robust training on how to do appraisals.
Yeah, that's true.
correct.
You're absolutely
We
right.
don't have that. Like if there is one, there are trainings which are focused on the appraisal process.
Right.
You do lots of these points are
Automatically.
It's wrapped up
It's wrapped up.
Yeah. Okay.
So sometimes what we do is, we create these 5 to 7 minutes short videos, and then as a part of induction process, those are shown, to the at least at the managerial level, or whenever there are promotions at that level, when they are escalating, to the manager level, then you show those videos as an induction process. So at least being aware of the issues is one, and then as you go along, further training. But that's something you can
The
consider.
sexual harassment training requirement for managers, is there a definition of who has to be trained?
It's for all employees.
All employees.
For all
Including
employees.
Including the committee, which is
No,
called.
so we have a committee that's constituted.
They also
already.
need to be trained.
No. So we have a committee that's constituted. The question is now the training on the content of the sexual harassment law and the policy that is in the company. I don't think we've done that, Francine.
We have.
The
It's
training
been
on
done and,
sexual harassment.
the training has been done. I mean, we send this policy on a periodic basis as a refresher to the entire organization.
Yeah, but mailing it out doesn't constitute training, does it?
Yeah, not
I'm asking,
face-to-face
what's the
training.
requirement?
No,
Does it have to be face-to-face training?
not really, but it just says training now. Sending policy may not really be seen as training.
Okay, so Tricia, let's connect.
And
on
how do you
that training done, and
how do you
often
know
does
if a person has gone through the policy? Is there a Q&A? Is there a acceptance button? I mean,
There's no acceptance button.
no, I'm just trying to
Maybe-
understand.
Maybe for India, we may have to look to putting this into
No,
LMS for
I
India.
remember in LMS you have.
LMS India for
yeah.
sexual harassment training, we may have to do a module for that. Can I ask how frequent this has to be done? How frequently?
Nothing under law. I mean, some companies are doing it on an annual basis, but no particular legal clarity.
Let me follow up then on what needs to be done for that in India and we'll put it into LMS if possible. for India.
Yeah.
Yeah, I think
Okay.
we have to initiate with the LMS team and they can.
Okay.
Okay.
So in case there could be one example where you still don't have the time, and the person is his behavior is more creating more damages, and you don't have the time for documentation. Then how should be the approach?
After hours homework.
So you don't have a choice. You may not have the time, but you don't have the choice. So either do it yourself or hand it over to HR or something. But
It has to be
you
done.
can't just not follow a certain protocol before terminating.
No, I'm telling about these documentation can be there's no period to it, right?
No, but
It can be 1 day to any time, right?
it doesn't have to be
Can
done
we
live.
also strip him off the man management responsibilities?
Then
cannot
he
be
would become a workman.
Okay.
Just now he gave an
Right,
example of that. Just now he gave an example. The manager role has been demotivated and then he went in a labor court.
No, at times this happens, right?
We have to be little patient.
I think it may be important also for, as mentioned earlier, to figure out your team and figure out who is at a
Pick up
manager
the
level.
early signals and start doing it.
Yeah.
Pick up the early signals from the
Yeah.
individual and start doing it.
No,
Have
that is
something in
one
place
thing.
before you.
Yeah, and categorization, probably not necessarily on a quarterly basis, but an annual basis when the promotions happen and all of that. You need to see now which category is that person falling, right? Whether it is a workman or manager. So keep those notes available with you that then the way to handle may be different. So as he rightly said, we need to give you now the next step is if it's a workman category, what are the do's and don'ts? If it's a manager category, it's slightly sort of easier to approach. So that is something the next level of nitty-gritties have to be gotten into. But as he said, there is unfortunately no option but from a recording and documentation.
If you don't want to get into litigation.
Yeah.
So if a workman is being transferred from one product division to another product division, can the government go to the court saying that the intent of this transfer is to terminate me or? So what is the precaution that the company can take?
There's a whole book titled Transfer of Employees Under Labor Laws. There's a thick book. And again, there are...
It's fact specific.
Yeah, it is a subject on its own. I can't answer that question with a yes or a no because there's too much of jurisprudence in terms of...
Yes, then what is the precaution that the company can take?
Get his consent to transfer. If he is willing to transfer and willing to accept that transfer,
so if he has accepted the transfer, that's fine. Like
yeah, that would resolve most of the issues.
So it is a problem with us, especially at territory manager level. We don't have well-defined roles. Look, in pharmaceutical and all, what happens at representative levels, the roles are so well defined, and they have reports for each of those roles. People can be actually even representative level those reports and roles.
But then representative level, it's very difficult to take actions.
Yeah,
that's why, like in Kerala, no, you cannot do anything.
Union and all.
That is different. Yeah.
But in general, if you have, like suppose, if they are supposed to do certain number of calls, and over a period of time you can prove that this is not happening. So on those specific roles, if you can have reports and over a period of time you can develop it.
Again, like these people are also like, no, you see, the moment you document it, they are not going to accept it. Like they are going to like immediately say that it's because of the dynamics. It's like they will never like, no, you're talking about like a performance, and you're telling like you've not been performing. You'll say like it's the market.
No, they will never accept it. They will have another 10 points.
They always have like no.
They will have
counter documents like command.
What else? You will also have a case.
And you'll know on what lines he's thinking. If you haven't documented it in the first place, that question would never arise. But if you document it and he comes back with another 10 points contradicting your points, you at least know in what line he's thinking and you can start working towards it, you know.
So if I have to transfer, so I'm talking about the transfer. So do I need to say why is the transfer from this division to the
Your answer is in this. Transfer of employees under labor law.
Yeah. So do I need to specify the reasons
264
of
pages.
this transfer?
You have to
again, I
prove that this position is redundant.
I mean, transfer from where? From where to where? What is
the department, the role, or is it the role that you're talking about, or the location?
So the role.
Role.
Yeah. So the location will be same. It can be same, but then the role.
See, I think it's a slightly subjective matter. I'll give an example. So suppose somebody who's in a technical role, right, has a certain requirement, you know, filling in that
it's the same role. So because today he is a salesperson, I'm moving him to a different product division.
I do mean that it's not as if you're changing from technical to sales.
How would you document it in your normal?
But then how does it help?
But that's not. If that's the case, then that's not a transfer.
Yeah,
it's not a transfer.
It's just you're just changing the portfolio or in terms of product
portfolio. I mean to say transfer because today he's in a particular product division.
Right.
I don't think then that's not a transfer.
From a legal contractual point of view,
that's
not a transfer.
Yeah, that's right.
He's still an employee of the same company.
Correct. It's like saying that today you are handling walls, tomorrow you will handle...
My question is, can the employee approach the court saying that the intent of this transfer is today, he is in a product division which he is familiar with, tomorrow he is going to a product division he is not familiar with.
I don't think that...
How do you do this transfer in the normal course of business? I mean, just to understand, how would you go about it?
So look, there are several cases in the courts regarding transfer from one location to the other, and so there the employees would say that this is causing
whatever is the reason, you've been transferred from this headquarter to this place. So I think
can you approach?
In short, if your question is, can an employee challenge it? In India, employees challenge everything. Okay? So can they do that? Will they challenge? I think the answer is they may, they could. does the company have grounds for justifying it? I think the answer is also yes. I think the company is justified in doing that. I think what you're asking is whether that amounts to constructive dismissal, and I think the company has a case to say it does not.
No, correct.
Yeah,
I mean, it's very fact specific, but I would say the company can justify such a move.
I think I would
in general.
I think I would, sort of caveat by saying that by itself it doesn't really matter. I mean, we have a very good sort of argument against that. But if it is shown that, he was transferred, then within, quarter, his performance evaluation is done to say that, see, you're not performing this, that, and he was actually doing very well in the earlier one overall. Maybe because of his attitude or something, you're not able to figure out how to deal with him. So you shift. And then, so all these ancillary things together may be viewed together as a whole thing, right? But by itself, it doesn't really matter, right? So it should not be that, then you say quarterly that, where he was doing all his sales pitches appropriately in the earlier role, and now because he's still struggling to figure things out, and then you say you're not performing, therefore we are, poor performance dismissal. That becomes a tricky one.
At least have some basic communication that you were offered a different role and you accepted that
as a
role and
challenger
all
or
of that,
whatever,
and accordingly you are now being transferred to this department. Something to say that it was an offer from the company and he accepted it. I think it's good enough from a documentation perspective.
Well, I think we've come to the end of our session unless you have any other burning questions that you want to ask today. Otherwise, we're happy to take questions offline, happy to deal with them, on a completely separate training.
Ask all your questions today because from tomorrow it will be chargeable, so might as well give it to our best shot.
You mentioned the workman includes apprentice, right?
Yes.
So you mean to say the intern it includes?
Yeah, see, interns again, it's what your relationship is with the interns. And there are apprentices who are under the Apprentices Act and who are meant for a longer term. So those are likely to be categorized as workmen, but with limited protection under law. They don't have full protection like workmen, because whether they are employees or not is it's another question. So there have been views to say that they remain as trainees for the period of apprentice. But for that, have you got them under the Apprentices Act, which to me answer is no, because nobody really complies with that act.
But then the Apprentice Act says that you need to guarantee certain, hiring those certain percentage of those apprentices to the apprentice, something like that.
There's absolutely no obligation to hire the apprentice under the Apprentices Act. I mean, if that was the case, nobody would have engaged apprentices. Because the quality of apprentices is like really shockingly poor.